And we're going to go on Proper Title's Facebook page. And we should be live in just a second, Dean. Thank you for joining me. Okay. And there we are. All right, cool. Well, hello, everybody. Thank you for joining us this morning. My name is Sabrina. I'm the Director of Digital Media and Education at Proper Title. I am here today with Dean Lurie, one of our real estate attorneys and friends. So Dean, thank you so much for joining us today.
Hey, it's great to be back with you again. We had so much fun last time, so thought we'd do it again.
Yeah, if you want to see Dean's last Facebook Live, just scroll down and you'll see him there. You'll see us talking back in, I think it was June. And so Dean, like from June until now, September, what do you say? Has the market stayed the same? What have you been seeing across your desk?
Well, looking back on our past session, I think things have, shifted a little bit. I think last time we were talking about how hot the market was, and we were talking about seller terminations on getting higher offers, sellers terminating for no reason, and multiple offer situations. Market slowed a little bit, mainly due to the higher interest rates in the sevens right now. Historically, not terrible rates. However, we're seeing roadblocks from people moving out of their low rates that they've achieved in the last couple of years. They've raised in the 2s and 3s that they've gotten over the last couple of years, and now you're asking them if they want to move to a 7% rate. Really inhibits a lot of these sellers to move, which limits the inventory of available properties right now. So inventory is still tight. I think the prices have remained pretty stable. They haven't come down, to my knowledge, anywhere because of the limited inventory. There's still buyers out there, but not much to buy. So we've seen a little bit of a slowdown. It's cyclical. We expect next year the rates to hopefully come down again. I've heard in the media that a lot of buyers are saying that, or sellers are saying, when the rates come down to like 5.5% or lower, that'll kind of be a measure for a trigger for them to make a move. Yeah. So hopefully next year we'll see some rates come down and we'll have some more action in the market, and we might see a huge boom again. When we see the rates come down to, they're saying 5.5% or lower, you might see a huge boom, and you might see some price increases they're predicting for next year.
Yeah, it'll be really interesting to see what happens. One of my little soapboxes is always about hiring professionals that do this all day, every day. So one, hire a real estate attorney, but two is just based off of everything that Dean just said. For those of you that are listening, everything is hyper local though. So this is great broad overview, but if you are looking to buy or sell in a particular neighborhood, especially particular neighborhood of Chicago, please be sure to hire a seasoned real estate broker that knows that market. Okay, I'll get off my soapbox. So let's talk about a couple things. So one of the things that I wanted to have this conversation with you about today is about the attorney review process. And a lot of times, especially when we were having so many multiple offers, but even still today, a seller gets a great offer from a buyer, right? And sometimes the buyer has lost out on multiple deals, especially if they've been looking for a while. They've lost out on a lot of deals and multiple offers potentially, and they come into the attorney review period, but they're not 100% confident even that they want that property, right? And so, but they come in because they want to get their offer accepted, and they're excited, and they're like, oh my God, I won this offer and I'm in attorney review. Have you been seeing that a little bit, like that mentality?
Yeah, you've seen a lot of buyers, lose out on property. Like the inventory is limited. So a lot of competition still for those good properties out there. So buyers do get fatigued. They might have been in a couple deals. They might have lost out. And they come in attorney review, and maybe they're not sure if they want this property. They just wanted to get something under contract. And they know they have 5 business days usually under these contracts to terminate, really, for any reason. So, you do see buyers potentially changing their minds during the attorney review process and using the attorney review to terminate for reasons I don't think are proper under the contracts, but this has been going on for a long time. And so you really have a 5 business day window to really get out for any reason as a buyer. So they do have that flexibility.
Yeah, which is a little bit scary for sellers, especially in markets like we have right now, where the seller needs to also buy something. And so they're also on the other side of the deal in a competitive, I would say the majority of sellers anyway, are looking to sell and then buy something. So they can't move forward with their buy until they know that their sale is most sellers, that their sale is under wraps. And now you're in this contract with the buyer. And it's a pretty stressful time, like during that attorney review period for the seller to make sure that their deal is going to go through. So, how do you what do you, I don't know, I feel like a lot of buyers think of it as almost like another negotiation tactic. They may put in an offer overpriced, but then think that they can get more money off of it during the attorney review process. Tell me some examples about kind of like what you're seeing.
Yeah, well, I think that, attorney review has been used improperly for many, many years now. I mean, this is a unique kind of contract term that most states don't have. I mean, I think it's unique to Illinois, and I think it's also unique to
We might have froze up, Dean. Oh no. Dean, are you there?
Sorry, I lost you for 1 second.
Yeah. Oh, well.
Okay, sorry about that internet issue. Anyway, I'm not sure where I cut off, but we were talking about, the attorney review period, 5 business days. The buyer and their attorney can terminate a contract for literally any reason. That's what the cases say. But they have to have good faith. We talked about good faith last time. So
Yeah.
the parties have to act in good faith. The buyer's got to make proposed modifications in good faith. They have to ask for things that are pertinent to the transaction. As far as inspection items, you're right. Buyers try to renegotiate deals on attorney review. The purchase price can be renegotiated by inspection credits. The buyer is free to ask for repairs or credits during attorney review, and that could act as a retrade of the purchase price. So nothing is set in stone during attorney review. Usually the buyer only has $1,000 earnest money deposit up during attorney review, so there's not a lot at stake. So you don't see a lot of litigation from buyers acting badly during attorney review because they only have $1,000 up. The seller wants to quickly move on. If the buyer is going to terminate, you don't want to hold them to anything. So you see a lot of buyers getting away with using that 5-day period for, any reason whatsoever. They lose their job, or their investments go down in the stock market, or they find something else during the attorney review. They can use, any reason at all. They'll just tell their attorney to get out of it, and their attorney, a lot of times will send a letter saying that they don't approve the contract. But it's, again, we talked about this last time, they're not disapproving the terms of the contract. They're, disapproving it because their buyer changed their mind during attorney review. There's no way to prove that because you don't have to give a reason. So you're really in limbo as a seller during that attorney review negotiation. Nothing's really set in stone. The contract's not really hard, earnest money not refundable during that period.
Yeah, so typically, right around the Chicago and the Chicago suburban areas, the counties surrounding Cook County, et cetera, our contracts are written that when you go under contract, you have this $1,000 earnest money, and then after the attorney review is over, the rest of the earnest money is due into an escrow. So when you just have that $1,000 that's sitting there, when the buyer puts up that $1,000, what are like the risks associated with that money that they have then? And does the seller ever really get it? Like if the buyer just backs out of the contract, is there ever really a case like that?
Yeah, I mean, it's very rare for, a forfeiture of earnest money. It's very hard to get because earnest money goes in escrow, usually with a listing agent. And the listing agent can never give that money to the seller unless the buyer signs off on it or there's a court order. Both, very difficult to get when there's an issue or a dispute. So that first $1,000 is just a good faith gesture that I'm putting some skin into the game. I have some money up that's tied up pending this attorney review and inspection. Once that's done, now there's sometimes 20% put in escrow, which is significant for a lot of properties. So now the buyer's got some real skin in the game, but there's other contingencies out there. A lot of times there's a financing contingency out there. In addition to that, if it's a condo, there's usually a separate contingency, separate from attorney review, by the way. A lot of attorneys don't understand this, that there's a separate 3-day review of condo documents. So you can agree on attorney review, and then condo documents come in, you've got usually 2 or 3 business days to review and approve those to make sure the condo is in good shape. So those are 2 separate contingencies, and then financing contingency. The problem with, so the contract, the earnest money is not non-refundable until all these contingencies are waived. The final being the financing contingency. And what you're seeing a lot, and this has been going on for years too, the lenders are taking forever to get their loan clear to close. And that goes all the way up into the closing date, a lot of times a day or 2 before closing. Yeah. So the deal is really not non-refundable until that clear to close comes in, because what the buyer's attorney will do will protect their client and their earnest money by extending the financing contingency until they get it clear to close. And the lenders, they're not so busy anymore, but they were, at the times when they're very busy, they got to get through appraisal. They have to gather documents from their borrower. A lot of times they're waiting on their borrower. So you blame the loan officer, but it's not on them. They don't get that clear to close a day or 2 before closing. So you don't, as a seller, you're not really hard on that, earnest money deposit, and sometimes a day or 2 before closing. So very stressful, like you said, for a seller who's maybe buying something else. And it causes a chain reaction down the line because they're buying from someone who's selling their property, who's buying something else. So it really can affect a lot of people waiting on these clear to closes. So there's a lot of contingencies down the line. So, the only way to get the earnest money is if all the contingencies are waived, financing's waived, we got a clear to close, and then the buyer somehow changes their mind and says, I'm not buying this anymore. Or in that case only, a buyer may forfeit their earnest money. But even then, the buyer's got to sign off on it. And sometimes they still, dispute it for various reasons. And what usually happens is there'll be some kind of compromise, and the buyers and sellers will split up the earnest money, maybe 50-50 or, another method, but very rare for a straight forfeiture of the earnest money. Now, if the seller, brought suit against the buyer for default, after all contingencies have been waived, the judge would probably rule in the seller's favor and 100% of the earnest money would be forfeited, but that would take a lawsuit. A lot of time, a lot of money, and it might tie up the property. So sellers really just want to move on. If the buyer's not going to buy, they want to move on and get it sold quickly and get rid of this buyer. So it's usually resolved with some kind of compromise on the earnest money.
I want to go back and talk about something with contingencies and attorney review, but prior to saying that, if the seller does take the buyer to court in order to get earnest money back, are they allowed to sell their property during that time?
Yeah, that's a gray area because a lot of title companies will not insure the deal unless they've got proof the earnest money was returned from the previous buyer. So technically the contract's been terminated. We all agree on that, but there's an issue over the earnest money. And I know Proper Title and many other title companies want to protect themselves for any claims from that buyer. They want to make sure the earnest money has been resolved. Right. So it depends on the title company and the risk they want to take, but many times the earnest money needs to be, resolved and returned or forfeited prior to, clearing title for the next buyer.
Right. Yeah. So that's just another kind of delay potentially in the sale of that property too, when you hold up the earnest money that way. So that's why I just wanted to bring that up. But okay, to go back. So in the attorney review period of time, which is what we're talking about here today, we talked about, like you mentioned, that there's also the condo doc review contingency. And so let's kind of like talk a little bit about those potentially 5 days. Now that's a written in number in the contract of how long attorney review is, and that's negotiated between the buyer and seller at the time of the contract signing. But let's say it's 5 business days. Is it true that there is like the attorney review contingency, inspection contingency, and then if you're buying a condo, the condo doc review contingency? Are those 3 separate things, or are they all one thing?
There are 3 separate contingencies. They usually run around the same time though. So the attorney review and inspection contingency usually are 5 business days from the date of acceptance. They run together. The condo doc contingency is separate because sometimes we're waiting on condo docs. We don't get like something called the 22.1 condo disclosure, a very important document when you're a buyer of a condo that will, give you a snapshot into the health of the condo as far as amount in reserves for future capital projects and also any big special assessments coming up. That's the biggest thing I look for, are big projects and big specials that the buyers walk into in a condo. So you might not get those condo documents during your attorney review. You might get them later. If you do get them in that 5 business day period, like right away, they can all run concurrently, but they're actually 3 separate contingencies, but usually running around or at the same time.
Yeah, that's actually super interesting, right? Because, and then also with the attorney review that typically, like you says, run concurrently with the inspection review, even though it says potentially 5 days or 7 days in the contract, those can be extended as well, right?
Yeah, so that's a big misconception. So people think that since attorney review is a 5 business day period, that we have to come to an agreement on that 5th business day, but that's not really the case. What that means is the 5 business days are the time for which the parties must submit their proposed modifications and inspection requests. So you can wait to the 5th business day till 5:30, 6 o'clock at night. As long as you make your submission within that 5 business days, you're covered, because now we're in attorney review, and the consensus is that attorney review is generally extended now until the parties either come to an agreement or either side terminates the contract. So the 5 business days is to get your comments in. If you don't get any comments in that 5 business day period, you waive your rights. So you either need to extend that period. Now you might get to the 5th business day and there's a problem with the inspection. So we extend that period to get our comments in a lot, and that's routinely granted. But we don't need to agree in that 5 business days, but either side needs to get their comments in by that deadline or they waive their rights.
And what does it mean when they waive their rights?
So if you're a buyer and you don't submit any proposed modifications to the contract, then attorney review is waived. Now you owe your earnest money and you're going by the terms of the contract, which is fine. Sometimes parties don't even want to, provide comments because they don't want to rock the boat with a seller who wants to. We talked about this last time. Now you don't want to give a seller a reason to terminate. So if you don't give any comments, you don't really give the seller a reason to terminate the contract if you really want this property. So sometimes you'll waive attorney review based on the terms of the contract. If you approve everything that's in there the way the offer was written, your earnest money is then due 2 or 3 business days after that date. And then your earnest money is non-refundable, subject to possibly a financing contingency or that counter doc contingency we talked about. So that's really the deadline to get your comments in or make a declaration you're not going to make any changes to the contract.
And is that something that you decide kind of with your client, with the buyer, right? Like if the buyer says to you, this was, this is my dream home. This is my property. Like, I'll still do an inspection, but I don't what would they say? I don't want you to write anything to the seller yet because I don't want them to have anything to respond to. Is that kind of how it would work?
Yeah. For the most part, it's up to the buyer. You're right. If they want the attorney to make changes to the contract or they want to ask for an inspection. Most times buyers do want the attorneys to make their standard, customary comments to the contract. Attorneys have usually form letters for the various contracts, the multi-board and the car contract for what we want to change. Those contracts have some issues in them. They should be updated, by the way. It would make our lives easier, but we want to correct issues in the contract. We also want to ask for history on the property, usually past issues with water, especially as a hot topic issue. Past water infiltration, past insurance claims, certain reps and warranties we want about the mechanicals or the roof or what, but the answer is most buyers do direct their attorneys to make their standard comments with the right to say, look, if you don't agree to these changes, fine, we're still going to move forward, or we have a right to move forward under the original contract. That's what my letter says. So if the seller says no to them, we still have a right to withdraw them. I think that's important. So you could say, look, we want to make this change, but if you don't like it, we have a right to withdraw it. Yeah. So for the most part, buyers do want their attorneys to make those standard changes to the contract, but you do risk, a seller termination during attorney review, especially on a property, like you said, that, you have to have and you don't want to take any risks at all. I have seen that where buyers would direct their attorney not to make any comments at all.
Yeah, it's crazy. It's a crazy market. It's crazy, just the feelings that buyers have when they do end up finding, especially with the low inventory market, they do find this property that they want to live in, especially if we're talking about a family and schools and all these things, right? And so let me get back on my soapbox again. For those of you that are listening, it is so important to use a seasoned real estate attorney in these contracts, because they know all the ins and outs, and they talk to your clients about, or the buyer, seller, whoever, about their motivations and what they want out of this whole process, and are able to implement those things and write those things into the letters and everything, right? I mean, it's so important because it's not just a templated letter. Like, you might have your own like template, but it's not a templated like letter. It's very specific to whatever the transaction is.
Absolutely. I mean, it's so important to have a broker, like you said earlier, that, is knowledgeable in that area that you're looking at. Because in Chicagoland, each neighborhood is different, each suburb is different. So you always want someone local who's really familiar with the market in that area. I mean, the most important advice you're going to get from your broker is the price you're going to offer as a buyer. I mean, the market and the comps are so important, and a local broker is really going to know the market for that. The price is the most important aspect of the offer. And then also, a seasoned attorney who does these kind of transactions, who doesn't practice in other practice areas, who dabbles in these kind of deals. You want someone who knows what they're doing, because, we talked about it last time. This is a specialty for attorneys as well. And there's, big consequences to, making an error by an attorney, which you see all the time when someone doesn't know what they're doing. So seasoned professionals for both the broker and the attorney, and also the loan officer as well. I mean, those are the three key components of the deal. You want to make sure that they're, seasoned, they know what they're doing, they know the local area. So really important to have good people to make the transaction go smoothly.
Yeah, thank you. And thank you for, is there anything else did we miss something?
I don't think so. Unless you wanted to cover any other topics or anything else you were thinking of.
Well, I guess the only other thing I kind of want to talk just very briefly about before we close out is, when we talked a little bit about having inspection issues on the property and using that as a time to kind of almost like renegotiate based on credits that the seller may have to give the buyer. But what is kind of the rule of thumb, I think, for like older mechanicals or older appliances? Because I know that that's always kind of a big thing that comes up, like, oh, it's getting close to its projected age. And like, what does that mean for the buyer and or for the seller?
Yeah, so that's a great question. And this comes up all the time. So when, buyers tour a property, they're not looking in the mechanical room and looking at the stickers on the mechanicals for what year they were installed. So that's really comes in later when the inspector comes through, and you might find out only after your inspection that the furnace is got 1 year left on its useful life, and the roof is going to go soon. So you find these things out later. What the multi-board contract says is that you are not supposed to ask for a new mechanical just because the old one is old, if it's currently operating in good condition. So the contract says that. However, the attorney review provision says, well, we can negotiate and change and modify any terms of this contract except for the purchase price. So the inspection language is actually negotiable. So the attorney can strike the language that says, well, you can't ask for a mechanical. So, you do see people try to retrade, like you said, the purchase price, because they're going to have to, change out the furnace next year or the roof. That comes up all the time. But I think it's totally inappropriate to ask for a new furnace because the other one's old, even though it's operating, even though it might only have a year or two left. You're buying an older home. That's part of the deal. I mean, I would like to see, I know in certain states, the seller, before a contract is signed, provides buyers with a list of all the ages of the mechanicals. I mean, that should be information you should have before making your offer. Then we could avoid all of this. So there should be some kind of, statutorily required information sheet on all the mechanicals, the age of the roof, the age of the windows. So the buyer, before they're making their offer, knows this information. Yeah. Then would there be no, renegotiation of it on inspection. But this does come up all the time. a lot of times buyers, a good idea is sometimes to get a home warranty. And that's something that, by the way, if you're a broker, I would make sure you put that in the original contract, because to negotiate that later is kind of also retrading. So if you think the mechanicals are old, maybe negotiate a 1-year home warranty that would cover all these mechanicals that they go out within the first year. And sometimes a replacement of those. So, those cost between $600 and $800, but they're a great product. A lot of people love those for aging mechanicals for their first year. So that's something to look at for sure.
Yeah. And I do want to give a shout out to some really awesome real estate brokers that do provide the ages of all their mechanicals and appliances and work that's been done on these properties prior to even putting the property on the market. They have those things available. So I do want to give a shout out to those brokers that do that, because you're great. I think that avoids a lot of these concerns that happen during the attorney review period. Like, transparency is key because it's going to come out anyway, right? So have it come out up front. But yeah, I think that's all I wanted to cover today.
Great. I think we covered a lot, and it was great to be back on your show.
Thank you.
Always a
Dean.
fun time.
Thank you, Dean, so much for joining me, letting me tap into your brain and providing the information to everyone watching. I really appreciate your time.
Sure. My pleasure.
All right, everybody, have a great day and be kind to each other. We'll be back next week, Wednesday.
Bye.
Bye.